Thank you for joining the webinar. This is something new that I'm trying that I think might be helpful. The goal, the objective is financial advisors are an integral part of the estate planning process. They've been like that forever, but their role is expanding and it's becoming more common. And I'm going to have a conversation with Kelsey Murphy, who's a financial advisor, and we're going to have a conversation between a financial advisor and an estate planning attorney. What could be more exciting? And we're going to talk about things that we see happening, um, not just in our practices in estate planning, but in our practices in estate planning that involve financial advisors and attorneys. And hopefully, we're going to give a lot of practical advice that will be useful to advisors, but we're going to also try to highlight, which is why we need two of us, the interplay between attorneys and advisors and how we can all do a better job of it. I don't think I'm insulting anyone by saying we all got to do a better job on both from both perspectives. So the first thing, and this is how you're going to know that she's really a financial advisor. Here is a disclaimer that you can take a look at and is now part of the program. Um, wasn't that great? Now, just to make sure, Kelsey is not giving any legal or tax advice. She's not selling anything. And frankly, to disclaim for me as well, everything we're talking about, the laws change constantly. There's new tax cases, there's new asset protection cases on a regular basis, new regulations. Um, Everybody's circumstances are different. And that's probably one of the biggest flaws, Kelsey, that I see in planning, where, oh, and I can start this what hopefully be a series with a story. So I was at a conference, I won't mention the organization, a group of people, and I went down to breakfast, had coffee, sat down at a table, and I'm shy, so I wanted to introduce myself to everyone at the table. And I asked everybody what they do. And lo and behold, I sat at a table with six financial advisors. So I said, "Can I ask you all a question?" They said, "Sure." I said, "What is the biggest single complaint you have about estate planning attorneys?" Can you guess what they all said? They all said the same thing. You don't want to guess? I'm putting you on the spot.
Um, Let me guess here. Um,
All right, I'll tell you. They
yeah.
all said the same thing, which wasn't random and it wasn't rehearsed. That their experience with most estate planners is that most estate planners have like three techniques and three documents. And any client that walks in their office, they hammer whatever that client is into the square or round hole or whatever technique they happen to have a form for and know how to do. And that's a bad criticism because every client is unique. And I struggle from the opposite perspective. Somebody said, "How much is a will?" I don't know. What are you buying? Hamburger, two $5.98 a pound? Let's start with the plan. Well, but how much is it going to cost? I don't know you. I have no idea what your assets are. I have no idea what your objectives are. I have no idea what issues you face. And I can also tell you that it's, I can't even think of the last time a prospective client started by telling me what they thought their issue was and have that turn out to really be the same issue. It's often something, that's related to that or envelops that, but it's all almost always different because as lay people, they don't appreciate those issues. So hopefully by having conversations, we can help guide both the estate planning attorney, the accountants doing estate planning, and certainly the financial advisors. Um, let's start off with my biggest frustration with planning, and I think the role for financial advisors in the estate planning space is huge and vital, but oftentimes I don't see it handled correctly. And one of the issues that I see, and I put the blame on clients first and foremost. And I think it's going to get dramatically worse as AI becomes more commonly used. There's this really bad misconception that somebody is going to an estate planner to get a document. And that's why what I said a few minutes ago is what I hear all the time. How much is a will? How much is a revocable trust plan? You're not buying a document. If you want to buy a document and you actually know what document and what needs to be in it, you could go to an online I guess we shouldn't say the vendors, but any of the online form sites and just buy a document. The problem is that's not what anybody needs. You may need documents, but you got to start with a plan. And that's where I think one of the most important roles financial advisors can help their clients with is understanding that you need a plan. And I think there's critical roles that the financial advisor can play in developing that plan, but there's also critical roles that the attorney as an estate planner can play in developing that plan. And you can't make generic statements because there's lots of financial advisors that have incredibly experienced, well-known, nationally known estate planners on their teams. They're going to offer a different level of service, assuming those well-known people are engaged and involved on their particular client. Sometimes they're not. They're more of a policy figurehead generating content role. But if you have a level of expertise that's higher or lower, then the involvement you have in developing the plan should be higher or low, commensurate with the experience you have. And ditto for the attorney. I write and lecture all the time. When we were preparing for this, I explained that I always feel like I never know anything because the more that I write in the lecture, the more I realize I don't know. And when people, whether attorneys, accountants, financial advisors, seem like they know all the answers, how can that be? How can that be that anybody in such a vast, complex field can know all the answers? Um, so the roles will vary depending on the relative knowledge and expertise of the advisors that are involved in the team, but that doesn't negate the importance of each. Any thoughts or comments, and maybe even comment on how you see your role in helping clients with estate planning?
Yeah, absolutely. I think it's really important, especially for advisors, to kind of stay in our lane when it comes to estate planning. What I kind of see our role is really we're kind of the cash flow managers. We help to allocate money to different assets that we think are best for the client over time, given their goals, given their needs, given their circumstances, their family circumstances. Do they have children with any disabilities? Do they plan to, help their children pursue college? Do they plan to pay for that? What are their long term goals for retirement? But I think where the estate planner comes into play is really helping to execute that and making sure that all of those assets that we're working so hard to build are protected in the best possible ways and are also structured so that it lasts them as long as we need it to, but also making sure that it's going to the right places and the right people while also avoiding and having issues with anything that has to come to the estate of the client.
So I think the role of the financial advisor, you touched on it. Let me just emphasize something.
Yeah.
You as a financial advisor, how often do you typically see a client? Quarterly?
My larger ones monthly, my smaller ones quarterly, yes.
All right. So I, as an estate planner, if I do planning for somebody, it's hard to get them back 5 years later. They
Mm-hmm.
should come back. And I tell everyone, come back for an annual review. And by the way, an annual review, once you've done it once and you have a checklist, you get the financial advisor, the accountant, if it's a separate insurance consultant, get everyone on a Zoom or some type of web meeting. In 30 minutes, you can run through what's going on and make sure everything's being done. And part of the need for regular reviews depends on the complexity of the planning. If somebody just has, a poor will rev trust and they've properly retitled their assets, which often doesn't happen, which is an vitally important role for the estate planner to make sure the financial advisor is doing and that the financial advisor should be involved in. You got to understand the plan so you can title accounts properly. If I remember, I'm going to make a note. I'll tell a war story about that I see come up all the time. But if the plan is more complex and there's irrevocable trust, are they doing crummy powers? Are they making loans from the trust? Are they loaning money to the trust? Is it a grantor trust, a non-grantor trust? Are they administering properly? The more complex the plan, the more vital a periodic review is. And I think for wealth advisors to understand the plan is critical. And I don't know that enough wealth advisors understand the plan in enough detail. And I don't think a lot of attorneys take the time to explain it to wealth advisors. when we work, and I think it's different that for different attorneys, but we always generate memos or letters, some kind of summary or discussion of any meeting we have. And before we send it to a client, we send a draft to the wealth advisor. And if there's an accountant or an insurance consultant, whoever, corporate attorney, whoever's involved, they all get a draft of it. So everybody's on the same page. I think one thing that every client, and I rarely use terms that are absolute, but I think no client likes when they get one advisor telling them it's green and the other advisor saying it's red. They want all the advisors on the same page. So circulating a memo is a very cost-effective, easy way to foster collaboration. When I mentioned a minute ago about the importance of titling assets, I think every wealth advisor, certainly every attorney knows what that means, but it often doesn't happen. So we routinely find a client just died. Most of the assets the wealth advisor thought, without asking about the plan, without calling me, client didn't understand it, and the client didn't involve the wealth advisor when we did the planning because it's a new wealth advisor. I didn't know they got a new wealth advisor, but somebody getting a new wealth advisor getting a new client, it's worth having a consult with the client and the attorney to get everyone on the same page. We had provided trusts that I thought were very protective under the revocable trust for each spouse. Husband died, and probably more than half of the assets the wealth advisor had retitled to joint with the spouses. So they bypassed all the trust planning we did. And fortunately, because the exemption went up, if it had gone down, they would really have caused greater harm. But the asset protection, what if the spouse remarries? We really wanted all those assets protected, and they destroyed the plan just by improperly retitling assets. And I'm sure if I asked them, and I didn't want to pursue it because it's a fait accompli, the response would have been, well, gee, we saved them probate. No, you destroyed the plan of the trust that would have protected them. Um, One of the issues, and please feel free to comment, and I've seen this really frequently, and I see it with trust companies as well as financial advisors. Everybody that's involved on the planning should blow the whistle when they see it. The Smith family, they set up a trust. We had a case just recently, and this we see this all the time. The trust was titled by the wealth advisory firm, the Smith Family Trust. Okay. Was it the husband's revocable trust, the wife's revocable trust, husband's insurance trust, wife's insurance trust? When somebody had died, was it the irrevocable trust under somebody's will? Smith Family Trust is enough information to tell me the last name so we can identify the family, but I'm clueless, and so is everyone else, as to what the trust is. So you have to almost go back to the account opening documents and see what they did. If somebody isn't sure how to designate a name of an account so it reflects the specific owner, trust, entity, and LLC, very important to do. Any thoughts or comments?
Yeah, I think everything that you're saying really goes to kind of how the relationship between a financial advisor and an estate planning attorney should look. I think it really should be fluid. The advisor has to know enough about estate planning to know when it's time or who the most appropriate attorney is for that specific client given their circumstances and when it's time for them to actually start seeking a plan. But I also think that once the relationship is formed, it really should be very fluid. Um, if, for an example, if you and I are working together, if I'm looking to open a new account for the client, I might double check with you to see where do we want that account held? Is there a better way to do it than the way I'm thinking when it comes to estate planning that's going to benefit the client more on the back end? So I think it should really be two people who have very specific knowledge in their portion of the pot coming together and discussing how things should be put together so that the client is always in the best position possible, because at the end of the day that really is what's most important. How is the client going to benefit from having all of these things put in place? And we want to make sure that they benefit the most that they can from everything that's put in place.
If the surviving widow in the example I just gave is tragic situation, lovely people, if she remarries, now something like 60, 70% of the assets, maybe more, oh, much more, probably 70% of the assets are going to be in her name alone instead of in trust that would have been protective. What if she doesn't get a prenup? What if just out of the angst of all that she went through with their husband's illness and passing at a young age, what if she's like just distraught and gets in a car accident or does something, that's inadvisable and gets sued?
Yeah.
You undermine a whole plan with something as simple as the title to an account. The biggest, and I'm going to just be blunt, forgive me, well, you don't have to forgive me. I'm going to say what I think. The biggest cop out I hear is where a wealth advisor, well, I told the client I should talk to you, but they didn't want to spend the money. Well, I'm not going to ask you, but I'm sure you bill your clients, whether it's an asset management fee, an hourly fee, a combination, whatever it is, you do have a family to support. You have to make a living, just like I do. So if a client won't let you talk to an attorney, what I would do is tell the client, you're being ridiculous. I need that information to properly help you. And what I would do, and this is not done enough, is the advisor, and this is the same thing when an attorney tells somebody they need to go consult their insurance consultant or their financial advisor or their accountant. If the client won't do it, and the big excuse, the most common excuses I see are two. One, oh, nothing's changed. I don't have to go back. Tell me anything that hasn't changed in the last year in the world we live in. And two, he's going to charge me. She's going to charge me. Well, everyone's entitled to make a living. You know, maybe the attorney bills you by the hour and you have to pay them with a check. The wealth advisor may subtract it from your account, have other ways of doing it. Everyone gets paid. You got to do the right thing. I think wealth advisors would be protected better when a client is really not being reasonable to send a letter to the client saying, I need input on how these accounts should be titled. I don't have the full picture of your estate plan. And this to me is one of the things that I see, I think it's become more recent that almost every financial advisor is getting more and more active in estate planning. And that can be a really great thing for the wealth advisors, for the clients, and the estate planning attorneys if it's done well. But there's roles and services and input that the wealth advisor is essential for. And you talked about some of them, cash flow. When attorneys do trusts and they don't talk to the wealth advisor, they don't get forecasts done. How can those
Right.
trusts work? How can you move assets for asset protection or tax reasons into trust without making sure there's adequate insurance coverage, whether it's disability, long-term care, or life insurance? That's the wealth advisor's role to backstop and make sure the estate plan works. And most attorneys don't have that knowledge. But at the same time, while you may have all that knowledge that's critical to the estate plan, some of the technical stuff may not be really within the wheelhouse. And that goes
Right.
back to what you said earlier of staying in your swim lane. I think it's important for all of us to be mindful of what we do and don't know.
Absolutely. And I think, not to cut you off, but I think one of the
I'm
biggest
talking
roles
too
of a
much. Please cut me off.
one of the biggest roles of a financial advisor should really be um, observing what's going on with the client. Like I said, as an example, a client with a child who is in special education or needs special learning help or whatever it might be, you really have to look at the client's whole picture and understand what their financial world looks like so that you can implement those proper insurances that you were discussing. Because far too often I see with advisors that they almost become asset gatherers. They become, I want to be able to invest 200,000 in the market for you, or they have, these really big limits or thresholds where they won't actually work with someone unless they have $200,000 to put in the market or whatever
Or
it
2
might
million or
be.
5 million or 10 million.
Exactly. And I think what gets missed is that people who don't have those assets are actually the ones who can benefit from our help the most. And I think it's our job to really, we were talking about before life insurance and implementing long term care within that policy. Because if someone has a child with special needs and they may not have the assets um, to continually provide for that child throughout their life, if they became terminally ill or became disabled, that is life changing to them. So it's also important that we put the right things in place beyond looking at allocations into the market and then communicate those insurances to the estate planning attorney, because then it's going to be the estate planning attorney's job to make sure that those insurances that are put in place and any of the assets we do build inside of the market are secure and going to benefit the client most efficiently.
Let me comment and let's talk about a couple of the points you make because I think they're
Yeah.
worth emphasizing. So first, and this is something you mentioned when we were preparing for today,
Mhm.
there's certainly an arrogance amongst all professionals,
Mhm.
and all professions are guilty of this, that, I only take clients worth 50 million and up or 100 million
Yeah.
and up, a billion and up, or whatever it is.
Mhm.
But you said something very important. When people call me and say, "Will you take a smaller client?" I'll take anybody as a client if I feel I can give a value add to them,
Right.
and sorry for this, if they're willing to pay for my time. But the smaller clients often have issues that are very complicated. They're not going to be an esoteric estate tax issue like a better valuation adjustment on a note sale to a grantor trust. That's not going there. But they have issues, practical, real world issues that often can be very nettlesome and require some thought. But the impact that we as advisors can have is often outsized for the
Mhm.
smaller client. Somebody worth
100%.
50 million or $100 million, if they have a special needs kid, they're going to have plenty of money to pay whatever that kid needs, no matter
Right.
what. I mean, there's issues where you still need special needs planning because they need access to services, but
Right.
they're not worried about a kid going to college. If you have a client that's worth a half a million, a million, even $2 or $3 million, sometimes
Mhm.
even more, if they do something wrong, if they get sued and their assets aren't protected because they're in a high risk business with trucks and heavy equipment and things like that, the loss could mean their kid's not going to college. The loss could mean not enough money to
Right.
eat properly in retirement. So there's
100%.
an outsized benefit often for smaller clients. And I think collaboratively, we can do a better job helping those people than any of us can do individually.
I totally agree. And I think just from an advisor's perspective, obviously, like we were talking about before, everyone has to make a living. Some people choose to have minimums. But really, when I work with my clients, the most rewarding meetings that I have and the most rewarding relationships I have are the ones that I make the largest impact on. And that's not always someone, like you said, making 25, $30 million a year. So I think we could all better service just the citizens of the United States by being open to helping smaller clients. I know, like I said, everyone gets caught up in minimums and they want to feel like they're, scaling to a point where they only need to take a certain amount of clients or a certain threshold of clients. But at the end of the day, I think this field really is about helping people and making sure that all the fruits of their labor go to the best possible place and they can live a happy, wonderful life. So I think if we just even put an emphasis on helping some of those smaller clients, I think the world would be a better place for it, honestly.
I agree. And it's not just an end goal of getting documents,
Mm-hmm.
because too often I see people, how much is an estate plan? I have no idea. What do you
Right,
need me to do for you?
right.
But if I can come up with some planning ideas that are critical to protecting your life, what's
Mm-hmm.
that worth? The documents are the easy part. And I
Right.
think with AI and these online services, and not to criticize any particular financial firm, but there's one that, and there's probably a number of them that have advertisements. What's better, a will or a trust? You know what's better? Starting with a plan,
Yeah.
right? Um, One of the things that you also mentioned that I think is very important, to circle back, one of the areas that I see constantly overlooked, I don't specialize in special needs planning. I bring in
Mm-hmm.
a specialist to do it, but I try to stay involved because there's so many other aspects and sort of ancillary areas that I can help people with. But one of the areas that I see, and you mentioned it, and I'll let you comment on it after I talk for a second on it, is I see people come when they have a special needs child, adult or minor, and they'll have a special needs trust in their will, and or in their revocable trust, and they feel they've taken care of everything because they went to a special needs attorney and that's what they told them to do. First, some people are very wealthy, and some special needs people are not receiving government aid. So to just matter of fact, slam bam, routinely put in a supplemental or special needs trust is not 100% 99% of the time the right answer. It depends on the circumstances. And by the way, for clients that don't have a special needs family member, they probably will in time. You should have that provision in all the trusts. And that's another reason I like everything always in trust, because if there's a beneficiary that's special needs and you have a contingent special needs provision that can kick in, and state laws differ, you have to be careful. You already have the structure in place to help protect that person. But the piece that I often see missing, the second item, is disability planning. So I had a client that came to me that had an adult special needs child, and they prepared revocable trusts for the husband and wife. And the husband was named successor trustee in the wife's, and the wife was named successor trustee in the husband's. That was their whole plan. They didn't name anybody after that. What happens if they're incapacitated? And when they came to me, they were in their 90s. Who's going to help that child? The first thing I did is I introduced them to a wealth management firm that had a strong involvement with special needs type planning and had care managers on staff. And the care manager met with them the next week. And the week after, the husband fell down a flight of stairs. The wife couldn't move him. And what do you know? They called the care manager that had just met with them. And she went over and she helped them. The planning can't ignore the potential for disability and incapacity of the caregiving, especially parents that are on in years, for an adult child with special needs. And too often it's just focused on that special needs planning trust and not more. And in many cases, much more is needed. Any thoughts or comments?
Yeah, absolutely. I think your comment is really twofold. I think when we're talking about disability, there's the literal sense of it, where we can actually protect that. Like I was talking to you about how, something that I ask my clients a lot of times is, what is your largest asset? And nine out of 10 times, someone always says it's my home. And I always have to go back to them and say, it's really not your house, it's your ability to produce an income. And when something like that happens and you're out of work, in fact, I have a partner of mine in VIP wealth management. His daughter got in a horrific car accident when it was raining a couple weeks ago, and she's a nurse. She's out of work for at least a year. She had like 15 pins put in her shin and
Wow.
her feet. um, Not having cash flow to contribute to your plan can really derail a plan. And it's not oftentimes that you see self completing assets. For example, I'm sure her husband was potentially, contributing to a 401k. If he's not working, where is that income going into the 401k coming from? There's not. So I think protecting the potential for disability and protecting really your plan and the ability to follow through with it is extremely important. And then the other side of it is, talking about actually having a child with a disability. Your income is so important to just the support and the health of that child, paying for healthcare, paying for transportation if needed, any learning assistance that they may need. So I think if you ignore the possibility of disability, for both the caretaker and the child, I think you, at least from a financial advisor's perspective, I don't think you did your job correctly if you don't bring up the possibility that a plan can be derailed if something like disability is not taken into consideration.
By the way, in the common estate planning technique of non-reciprocal
Mm-hmm.
spousal lifetime access trust, I create a trust for my wife and descendants. She creates a trust for me. We make them sufficiently different so the plan can't be collapsed.
Right.
I don't see enough forecasting and modeling done for insurance needs to backstop that plan. If
Mm-hmm.
either spouse dies prematurely and a large part, say 30% of the assets were transferred to each trust, they kept 20% in each name. But if one spouse dies prematurely and you lose access to 30% of your wealth, will the surviving spouse get by? Maybe not in a lot of cases. What if the one of the spouses that's the breadwinner, or both spouses, one if one of them is incapacitated, do they have enough money?
Mm-hmm.
What about the formalities of getting money out of these trusts? People think that it's just a piggy bank. It's not. You can't simply take money in and out at your leisure and your whim. You'll lose what could either be tax or asset protection benefits. I think a great opportunity for all wealth advisors is to anytime they see these irrevocable trusts, especially if they have a lot of assets in them, contact the attorneys, figure out what the plan is. You can take the plan, and I'll mention FP Alpha. There's Estate View. I'm not as familiar with Vanilla and some of the others, but you could pop the documents into an FP Alpha or an Estate View, get a review. And by the way, you can't do that just into your general AI subscription because the model's not trained to know what to look for. So if you're getting something like FP Alpha or Estate View, they're trained by the people who develop them to, with all kinds of questions and prompts to get the right data back out of a document review. You need to understand what that trust is. You want to meet with the estate planning attorney, but you as an advisor need to review the what ifs. I find that in the vast majority of cases, we tell everyone to do this. People
Mm-hmm.
don't listen. They just want to get their trust done. But
Right.
that's an opportunity. I don't think a lot of people realize that, oh my, if somebody gets sick or incapacitated and they don't have long-term care coverage, maybe they didn't need the long
Mm-hmm.
or want the long-term care coverage before the transfer. But if you transfer in the hypothetical, I gave 60% of your wealth to trust, even if you can access it, it's not the same access as when it was in your pocket. You may want to
Right.
review if you're still working disability coverage and goose it up, or review
Mm-hmm.
long-term care coverage if you didn't have it, and certainly life insurance. I think it's a huge opportunity to go back. Lots of people created these trusts, and a lot of them may not be happy about it because they feel, oh my, now the exemptions for a couple 30 million. We didn't even need to do this. Well, but even worse, what happens if there's a divorce, disability, or death? The
Mm-hmm.
D's, the
And
D's.
I think what you're saying just kind of goes back to, we're talking about the advisor staying in their lane. I think the intricacies of these documents that you produce, that's where the financial advisor really has to kind of stay in their sector of work and kind of defer back to the estate planning attorney to talk about, okay, we have these things in place. The client most likely doesn't know what all the intricacies of the documents and how it's going to affect these different allocations we've made or different assets that we have in place. So I think just communicating regularly with the estate planning attorney is so important, just so that you are, as the advisor, very aware of everything you do and the consequences of them for the entire plan. I think not enough times is there, are there advisors that are willing to kind of take criticism and learn from an estate planning attorney. But at the
And
end of the
ditto
day,
on
it's
the
best.
reverse of that.
What'd you say?
And ditto on the
Yeah.
on the reciprocal end of
Yeah.
that, where an estate
Mm-hmm.
planner does a trust without any consideration to cash flow forecasting,
Right.
the growth in the assets in the trust,
Yep.
the tax burn the client's feeling,
Mm-hmm.
the lack of insurance coverage. That
Yep.
that is also very common. So I fault both professions equally. We need that communication because there's different gaps. And again, and I said this earlier, each professional will have very different levels of knowledge. You may have
Mm-hmm.
a person doing the estate plan who's an attorney, but more of a general practice attorney and not specialized in estate planning. You may have a wealth advisor that has, an estate planning attorney on their team that's got 30 years experience. So the roles are fluid. You can't just assume something, but
Right.
that's always why the communication is important. There's going to be times where the wealth advisor's team, maybe that you as the wealth advisor don't have decades of experience with really detailed estate planning, but you may have
Mm-hmm.
somebody on your team or accessible to you that does. And if
Right.
the attorney is a little weaker, well, you can supplement that. And if the
Right.
attorney's stronger, the wealth advisor should be happy and welcome that input. Because in the end, what the right thing to do for all of us is to get the best result for the client, not to be the big
Absolutely.
cheese. And a lot of
Yep.
people like to be the big cheese. You want to
For
comment
sure.
about the big cheese?
Yeah. Everyone loves being the big cheese.
At my age, I don't need to be the big cheese. I just want the work done right.
Yes, exactly. Exactly.
Kelsey, let's tackle a new topic
Yeah.
that I've been surprised about it, and it's frustrating to me, but it keeps coming up. And I'd like you to talk first as a wealth advisor, then I'll chime in. And if you do a great job, I won't even say anything. I've had just an ongoing series of clients where their wealth advisors are recommending that they have trusts for their descendants' kids typically that end at age 30 or 35 or some age like
Yeah.
that. And it frustrates me because protecting the assets should be in trust forever, as long as state law
Mhm.
permits. Divorce, we still have approximately a 50% divorce rate, although there's a negative correlation with wealth. Wealthier people tend to divorce less, maybe except for in California. I don't know. I don't know if that was nice. But divorce, lawsuits, claims,
Mhm.
we don't know what the estate tax is. I think it's absurd to think that we're going to have these $15 million exemptions forever. Maybe we will, but maybe in one of the
Doubt it.
next election or the
Yeah.
election after that, it could go back to 2 million or 3.5 million or something dramatically lower. So why would anybody not understand why you want stuff in trust? And if you really trust the kid, make the kid the trustee. You have to have a HEMS, health education maintenance and support standard, because then under
Mhm.
state law, the kid can be a trustee and a beneficiary. They don't have anyone to answer to. They can support their lifestyle, which is all most people are looking to do, and it's still protected from creditors or being included in their estate. Yet I get arguments, and I'm baffled. Why financial advisors would argue with me that their clients should have these trusts end? Any comment, thought? Maybe you can even explain it in better English than I did
Yeah.
for people. Then I can send them to this video to see.
Honestly, I think it goes back to what I kind of mentioned before. I think a lot of advisors would like to be asset gatherers. They want to focus on pulling money into the market, so you know that they can charge a fee. And what I think is really important is looking beyond that. And I think when you don't look beyond that, that's when you kind of get into muddy waters and might recommend something like that, like not having a trust past 30. To me and how I run my practice, in your 30s, you're maybe getting married. If you're already married, maybe looking to have kids. You're probably starting to really excel in your career. So maybe your income is increasing, your
And your
assets.
liability.
Yep, your assets are increasing, your liabilities are increasing, especially if you are starting to have a family. I think also, you know, specifically for business owners, as your business is becoming more established, you need to always consider lawsuits. I think a lot of times, very successful businesses, unfortunately, become people's lottery tickets. Um,
And
so
you
it
don't mean
would
the business owner, you mean the claimants.
Yes, correct. So it would baffle me as to why you wouldn't want something in a trust beyond 30, because I think beyond 30 is when it's probably most important to you in your future. I think also when you're, you know, getting to that age, maybe you have parents that are getting older. You know, if they didn't have the proper things in place, or maybe their assets aren't large enough, you're starting to take care of elderly parents. So I think protecting what you have beyond that age is so imperative. I I can't provide you any insight as to why you would not want your assets in a trust beyond 30. I think it's an imperative time.
And again, it can vary, but you can make the child, once they
Mhm.
hit say age 25 or whatever
Yep.
age you want, their own trustee. And as
Yep.
long as you have a HEM standard, they can be a trustee and a beneficiary, and it's protected from creditors. And by the way, if there's a divorce or a lawsuit filed, they should
Mhm.
have a trust protector in the trust, immediately remove them and replace them with somebody independent so they don't even have the position of being trustee. And if an
Right.
independent trust protector replaces the kid as their own trustee, they can't argue that it was pre-divorce planning or something like
Mhm.
that. They didn't do it. The
Right.
trust protector did it.
And honestly, maybe what some of the ignorance is to suggest something like that is maybe just not understanding enough about estate planning. Like, I will say it again and again that I think financial advisors really need to stay in their lane when it comes to estate planning. But I think you have to have the
But you got a big
wherewithal.
lane. There's a big
Yes,
lane there.
you do. I think you have to have the wherewithal to understand some of estate planning so that you're not harming your clients in that way. There's a difference between making a recommendation that's, you know, maybe not 100% spot on, and the attorney kind of explains to them why and what the better solution might be. But there's also a difference in recommending something that will ultimately harm your client.
I think there's no shame because I'm listen, if somebody points out something I've done wrong, I acknowledge it and I move on.
Yeah,
The goal is to do the best job for the client.
absolutely.
And as a financial advisor, there's all different levels and qualities of estate planning attorneys, but when
Yeah,
you work with good ones, it's a wonderful opportunity to learn.
absolutely. Absolutely.
And ditto for the attorneys when they work with smart financial advisors, because there's
Mhm.
always stuff to learn for us.
Yeah.
Just some of the things we talked about earlier with cash flow analysis, insurance
Mhm.
coverage, and so on. Kelsey, let me try to comment on something you said because I think attorneys and financial advisors seem to me, and I just kind of popped into my head, are in a similar position. So, as an attorney, if I don't offer planning, if I don't do things that are holistic, comprehensive, if I don't address
Mhm.
addiction issues and religious issues and special needs issues and all the different facets of what an estate plan is, if I'm just banging out documents, what future do I have? Because somebody can easily go to any of the web portals and get a pretty decent document that's valid in their state. I
Right.
think it's that, and as AI gets more powerful, those document form companies serve a purpose, but they're also very dangerous because people don't have a plan, excuse me,
Yeah.
when they're going. But if I offer no more than documents at a fixed fee, I'm not really giving people a reason to come to me. And I think
Right.
isn't it similar though for financial advisors? I mean, if all you're doing is giving an investment allocation, somebody can go to any of the online
They
services
can do it themselves. Yeah.
and get it for like, a modest number of basis points without it.
Mhm.
I mean, it seems to me that the real value that every wealth advisor adds is that it's like, wait a minute, client, yes, we're going to do an asset allocation, but before we just allocate, what are
Mhm.
your needs? What are your goals?
Right.
Are you taking on too much risk, too little risk? Are you really
Mhm.
allocated properly? And what about your insurance coverage? All the other things that
Mhm.
could blow up the client's financial future. You take that broad, holistic approach. So it seems to me that for both of the allied professions, taking a too narrow of a view is destructive to our relationships and what we can
Mhm.
provide. And
Yeah.
and and it's not that you shouldn't take a broad view, just be mindful of how much knowledge you do or don't have as you branch out to this broad holistic approach.
Yeah, absolutely. And I think one of the biggest things that I provide for my clients is I really try to be very educational. Like you said, if you just kind of go onto a document generator and get a document, you just kind of threw it together, you're not really going to understand how it actually fits into your financial world and your life in general, especially with estate planning, because there's so many intricacies. I really try to become almost like a trusted partner with my clients where they obviously have their own thoughts and their own opinions, but at the end of the day they come to me and say, this is what I'm thinking, what do you think? And I think that's really how you establish good, long lasting, trusted relationships, is just being a part of someone's everyday life. For example, for me, it might be looking over someone's health insurance elections that they have at work, or it might be making sure they pick the right investment option at their 401k that they currently have at their job. Really being educational, I think, serves the client so much better than just providing advice with a fee.
I think clients want it too. And I've
Mhm.
read, I hope I say his name correctly. Kitsy's has newsletters and so. I mean, it's in Financial Advisor magazine. I mean, it's all
Mhm.
over. The clients are asking and wanting their financial
Yeah.
advisors to provide insurance advice and estate planning advice and
Mhm.
everything else. And they should, but within the scope of what they understand.
Right.
I'll give you an example. So, if a client comes to you with existing documents, you can feed those documents into Estate View or FP Alpha
Mhm.
as two examples, and you
Yeah.
get back some really pretty impressive results. And it's only going to get better as the AI gets more
Mhm.
educated. But what that does is it gives you an incredible starting point to sit down and have a conversation with the client. Hey,
Mhm.
you got this old credit shelter trust that was set up 10 years ago. I'm guessing it was done to keep assets out of the estate, and maybe you'll get some write up on that. But right now, how much appreciation is in those assets?
Yeah.
If you're not subject to the estate taxes, you know the client's net worth, you're not going to help them from a
Right.
financial perspective. And if their net worth is $10 million and they're a married couple, or they have when in a new marriage, or they have a
Mhm.
carryover of a deceased spouse unused exemption for part of it, and there's a $5 million or $3 million credit shelter trust, they're not saving estate tax, but they're losing the basis step up on those assets. So
Right.
maybe it pays to evaluate, can you do something with the credit shelter trust? I
Absolutely.
think raising the issues makes the financial advisor the value add. because the idea came from you. Now,
Right.
it then gets more complicated. Should you terminate the credit shelter trust? First question is, does the document permit you to do that? And while you
Mhm.
may see something in a summary from like an FP Alpha or a state view as to how you can terminate a trust, it may not cover that. But that's a nuanced thing that I'd really want a lawyer to read the language of the trust to see if you can do it. Is it safe to terminate it? So let's say husband died, wife has a credit shelter trust. They did this when the estate tax exemption was $2 million. Now it's 15, and she's nowhere near an estate tax. Should she terminate it? Well, what are the odds of her getting remarried and that new spouse snookering her for the money? You got
Mhm.
to evaluate that. So,
Yeah.
you know, and if you terminate the trust, what is the liability of the trustee? The software is not going to, the AI is not going to tell you that issue. Do you get all the adult beneficiaries to sign off? Is there a virtual representation clause
Mhm.
where, say, a child can, that's an adult can sign off on behalf of their minor descendants who are beneficiaries of the trust? It gets pretty nuanced and complicated. But if you've started as the financial advisor, hey, you got this trust, there's a lot of appreciation, you're way below the estate tax threshold, you're the hero already. why
Right.
why dig into let's just terminate it when in fact there's all these layers of issues that really should be looked at.
A
And
hundred
I
percent. And I think one of the concerns that I have, at least with AI, is people just find it easier to consult AI rather than seeking out a human. And I think that takes the humanity out of it. I think that takes the ability for someone to be able to look at your life and look at what your needs might be. Like you mentioned, addiction, maybe there's mental health issues, maybe like we were talking about before, special needs children, maybe there's a hereditary disease that really runs in your family. You have a high risk for it, breast cancer being one of them. I think when you're using AI, you really take that kind of like whole life evaluation out of the picture. So it really goes to what you were saying of nuances. It's so important that, yes, maybe as the financial advisor, we bring that up. We want that to be looked at because it's going to greatly impact our planning. But again, that's kind of where then, in my opinion, at least, I would shift the responsibility to the estate planning attorney.
so let me you raise some very interesting points. As AI gets more and more powerful,
Mm-hmm.
I think the two realms that we as flesh and blood advisors will have, or the two advantages for the
Mm-hmm.
long term. One is humanity, right? All the human aspects. I don't know how AI can assess and deal with the emotions of the person in front of us.
Mm-hmm.
And that's really become to me, a critical part of planning. That's why when someone says, how much
Yes.
is a will? I don't know you. I have no idea what worries you and
Mm-hmm.
what keeps you up at night.
Right.
Maybe you want asset protection planning. Maybe you're a devout a Christian and you want to have concepts of stewardship integrated into your planning.
Mm-hmm.
It could be anything. You're Muslim
Right.
and want Sharia law. I mean, what is
Mm-hmm.
it that you're about? We need to understand that AI is going to be a long way off from getting there. And the second piece is creativity. So when I
Mm-hmm.
talked about dealing with a credit shelter trust, maybe you
Mm-hmm.
divide the trust into two trusts, terminate the highly appreciated assets, and leave the rest of the trust in place. Maybe you can have a trust protector action. Maybe you have a non-judicial modification agreement signed by everybody. You want to deal with indemnification of the trustee. I don't know that AI is going to reach that point of nuance for a while. But there's another concept that's very important. When we as professionals are using AI, we have the knowledge to discern
Yeah.
whether the output is a hallucination,
Mm-hmm.
and they do happen, or whether the output is just wrong. Don't forget that AI is drawing from public resources. So I have a subscription to Copilot, and I actually asked it yesterday because I was pondering this. What sources do you consult when I ask you a tax question? And
Mm-hmm.
it basically goes to rulings and regulations and tax court cases and so on and so forth. What it's not accessing is, for example, the Heckerling Institute on Estate Planning, where you have some of the
Mm-hmm.
most forward-thinking papers on estate planning every year, year after year. So
Mm-hmm.
it can't access some of the creative cutting-edge stuff that may be proprietary and not out there.
Mm-hmm.
So
I
you
agree. And one of the biggest things that I see with my clients are like, we'll have a meeting, we'll discuss some different options or kind of how my philosophy works, what I'm thinking for the client. And a lot of times they'll go back to the internet, they'll look it up, and there's a lot of false information on the internet. So now
That's a
they're
kind understatement.
yes, yeah, I know. I have to be
A
kind.
lot of garbage.
Yeah. Yeah. So people begin to rely on falsified information. And I'm not sure that that will ever go away with AI because under all of these, like you were talking about different court cases on tax law or whatever it might be, everyone's circumstances in those cases are different. And I'm not sure
Yes.
that, and I mean, it totally could happen. I could be totally wrong, but it would worry me that AI wouldn't be able to kind of articulate the differences between the cases and what the ultimate outcome was to be able to provide the right information for someone's very specific case or question or whatever it might be.
Most cases are fact specific. And if you have a transaction, there's a recent case out of Delaware, CES Trust 2007, something like that is the name. It's an odd name, but it was a case that upheld a domestic asset protection trust where somebody created a trust that they were a beneficiary of. And one of the key factors in that case, they adhered to all the requirements of Delaware law, and the trust was in place 7 years before the claim occurred. The trust was in place before the business that gave rise to the claim even existed. So the defendant won and his case was respected, which is a big thing because it's one of the few cases upholding a domestic asset protection trust. But in that case, there's so many things that the defendant did wrong, sloppy, improper. So, what's the nuance? And how many foot faults do you need before it becomes a problem? So the
Right.
case is valuable, but more valuable is the insight of somebody who has the discretion and the years of experience to step back and say, okay, there were good things and bad things done in the case. What can we learn to do a better job for you, the client?
Right.
And AI is not there. Let me just, because we should close up. One of the things that I fear with all of this, and I'm seeing it happening, and I don't know if you're seeing it as a financial advisor, but prospects, not clients, will call me up. I had somebody call me up. Can you do a beat it in Nevada? Yeah, I can do a beat it in Nevada. Do you even know what that means? And why are you asking for that? Does that even make sense for you?
Yeah.
And interestingly, I use AI all the time, but I don't always accept what I get, but I use it as a
Right.
starting point. Um, when I've asked questions of AI, it always gives you prompts for further questions. And one of
Mm-hmm.
the questions that comes up often when I ask a technical tax question, would you like me to draft a letter to your tax attorney asking this question for you? So even the inquiries we get from prospects, often which are as ridiculous as can you do a beat it? And by the way, a beat it is a beneficiary defective irrevocable trust. I can explain
Yeah.
it in a second because I should now that I said it. In Nevada, which is one of the better jurisdictions, the email that's being sent to me was written by AI. And we're starting to discern because you can tell the cadence and the tone of the
Yep.
AI written
Even
inquiries.
the grammar. I've noticed the
Yeah.
grammar is, yeah.
So to me, one of the most important things financial advisors can do when clients get in, and I'll do the same back for you when they say, "Oh, I don't need to pay somebody. I'm going to go
Yeah.
on to AI. They'll tell me how to address all these
Yep.
planning issues." No, it won't. Um, but we all have to educate clients that AI is very powerful. It's going to get more powerful, but it
Mhm.
has limitations.
You
A
know what?
benefic, Let me
You
just
know what is
explain this
now?
trust
Oh
because
yeah,
I
go ahead.
said it. A beneficiary defective irrevocable trust. Fancy name. Beat it. BDIT. Some call it a beneficiary defective trust, BDT. What it is let's say mom creates a trust for me. She puts 5 grand in it. I get a withdrawal right, sometimes called a crummy or annual withdrawal power. By virtue of me having the right to withdraw that 5 grand from the trust becomes a grantor trust for income tax purposes as to me. So it's disregarded. So now I didn't create the trust, mom did, but it's grantors to me. So theoretically, but I'd be very cautious doing this, which is why I knew the guy had no idea what he was talking about. I could sell $100 million asset. I'd get a guarantee from another truster family company to give some um, uh, substance to the trust because it only had the 5 grand in it. But now it's grantors to me. I would not do $100 million note sale to a beat it on the hope that it's grantor. But
Right.
conceptually, it should be a grantor trust, and you can use it for other purposes, which is certainly beyond what we're doing today. But that's a really complex, nuanced planning technique. It is not used all that often. I have no idea how many such trusts have been created. I'm sure there's thousands of them, but it's not millions. And for somebody to come with a concept like that, where do they get it?
It came from AI. Yeah.
Yeah, how about we start with a real plan? Talk to your
Yeah.
financial advisor, talk to your accountant. We'll all talk. We'll come up with a plan that works for you. We're not starting with some acronym you heard about from AI.
Right. An acronym that or not an acronym, an analogy that I kind of think of when it comes from to AI giving advice, whether it be my clients, your clients. Um, I one of one of the circumstances that's the most difficult for me to do a meeting in is when I'm on Zoom and the other person doesn't have their camera on. And that's because when you plan and when you propose ideas, and some of the best feedback you get is in people's facial expressions and how
Yeah.
they react to something that you're going over. So I think AI will never be able to replicate that. And I think that's one of the reasons that, like you said, you get these crazy answers or acronyms that they're throwing at people who then come to you and say, should we do X, Y, and Z? When in reality, it's kind of, it doesn't make sense for their circumstance at all. And if you were to present that idea and their camera was on and you saw their face, they might be like, huh? Like I don't know about that. But because it came from AI and people think it's so credible, I think it can get a little dangerous sometimes if people just always take what they read from AI.
I don't understand the mindset of the consumer that is our client. If you
Mhm.
take your car in, they'll hook it up to the computer and do diagnostic
Right.
tests to see what's going on. If you go to a
Mhm.
doctor, they're going to do a full blood work and
Yep.
check your vital signs before they start making decisions. Because even if you
Mhm.
go in and say, this hurts, or I feel this, or I have this problem, they want the big picture. And too
Right.
many clients feel that in our worlds of estate and financial planning, that somehow that's, you don't need that. You can just come to some exciting, acronym conclusion,
Yep.
and it doesn't work. Kelsey, we should wrap up. Why don't
Yes.
you kind of make some comments that would be helpful first to the estate planners and then to the financial advisors on how we can, from each angle, work better together to help our clients, which should be the real goal for all of us.
Yes, definitely. I think from a financial advisor's perspective, the answer is pretty easy. I think being open to learning, being open to criticism, to how your philosophy works or things that you've put in place. I don't think that anyone ever knows everything. I make it a goal myself to read a book every single week that has to do with financial planning, just because everything's like ever changing. And I think that financial advisors should really take that approach with estate planning as well. I think find an estate planner that you like to refer your clients to or that you think has done a really good job in the industry and learn. And I think that's one of the biggest things, honestly, for financial advisors is sometimes there's just not a willingness to learn or to hear another perspective. And I think that's really important. And I think from the estate planning attorney's perspective, just being very open to the why as to the advisor did what they did. I think understanding or almost having the perspective from someone who's been meeting with their client for however long it might be, taking their insight and their feedback as to how the client works, what really keeps them up at night. Are there issues that you know of that maybe came up in underwriting that you can provide some insight to? And then also, honestly, you're one of the only estate planning attorneys that I've come in contact with that are willing to kind of sit with you and talk and just,
I'll send you a
bounce
check for that nice comment.
bounce ideas off of each other. And I think that's huge. Like if we want to work as an integrated team, I think there just needs to be discussion.
And that discussion should happen first without the client present
A
so that
hundred
all the
percent.
advisors get on the same team.
Yes.
Again, the last thing any client wants to hear is one advisor say the attorney saying, yes, and the financial advisor saying no. They want
No.
everyone on
Yeah.
the same team. And we
Yep.
do a better job of doing that. Um, in light of your comments, let me just make one last comment. Many years ago, I'm guessing could be 10 years ago, one of the big wealth management firms actually came to me and offered to pay me, and they did pay me to um, poll like 20, 30 estate planning attorneys to find out why they didn't refer more clients to wealth management firms. And it was
Really?
really an eye-popping experience for me. And I did a whole webinar on it for the firm with the comments I got. The comments are really kind of awful. They don't know anything and they're just trying to sell products. And it was a very negative view. I hope that, the profession has gotten more enlightened since then. But I think many of the estate planning attorneys felt that a lot of the wealth advisors, and I know this is not certainly not the rule, but there were a lot of people that estate planning attorneys that felt that wealth advisors were undermining their ability to serve their clients and were merely looking to sell products and not to help. I hope that both industries in the 10 years since that all those calls were made and inquiries made have evolved to understand how important, an integrated holistic plan is where you need all the advisors. So
Yeah.
I think that's what we all need to strive for. Um, Thank you, Kelsey
Thank
Murphy.
you for having me.
And just so everybody remembers, we had a big caveat from her firm on the beginning of the webinar, and she's not given any financial or legal or tax advice. She's just provided wisdom and pleasant comments.
Thank you.
Nothing you can legally act on. But hopefully this was practical, and
Mhm.
we would both appreciate any feedback to see if our, dialogue back and forth about the kind of issues that we as a wealth advisor and an estate planning attorney grapple with together was of any help to you as an estate planner or a financial advisor. We would love your input, and if this is helpful, we can do this as a regular series, exploring the kind of issues that we see come up in practice, the good, the bad, and the ugly. So thank you
Mhm.
for joining us, and please do let us know any of your comments.